State of Cannabis.
This is the State of Cannabis News Digest, a roundup of this week's key developments in the cannabis industry.
Welcome to this week's Cannabis Policy Briefing, released every Saturday at 9 a.m. Texas is tightening enforcement involving Delta-8, THCA flower, and other hemp-derived products, while Delaware is building a regulated market for THC beverages. San Francisco is preparing for cannabis cafés, and Vermont is allowing larger purchases while testing a new kind of public cannabis event. Medical access is changing as well. Colorado has tested cannabis reimbursement through workers' compensation. Utah is seeking a new pharmacy for rural and medically underserved patients, and Hawaii is moving its medical cannabis registry to a new online system. Elsewhere, courts and lawmakers are redefining the rules. Michigan's highest court says cannabis odor alone is not enough to justify searching a vehicle. Rhode Island is restarting retail licensing after a federal constitutional challenge. New York is considering new labor standards for cannabis workers, and Idaho's latest medical cannabis ballot effort has fallen short. Stay with us for the details, the legal stakes, and what these developments could mean for patients, consumers, workers, and businesses. This broadcast uses AI-generated voices to make the program clearer, more varied, and more dynamic. The reporting, writing, and editorial decisions are guided by our news team. The voices allow us to present the show with greater range, pace, and personality. New listeners can subscribe wherever they get their podcasts, and if you already follow the show, please hit the like button.
And now here is the deeper look at the key events in the cannabis world this week.
We begin in Texas, where two separate legal and regulatory disputes are reshaping the market for consumable hemp. As of July 31st, Texas consumers have fewer legal hemp-derived THC products available. The state is prohibiting Delta-8, Delta-10, THCP, THCA flower, and other forms of THC classified as synthetically created. Delta-9 products may remain legal when they contain no more than 0.3% Delta-9 THC by dry weight. Depending on how they are formulated, that may include certain gummies, drinks, tinctures, oils, topical products, infused foods, and smokable hemp. The change follows a May ruling by the Texas Supreme Court. The court ended an injunction that had prevented the Department of State Health Services from enforcing a classification adopted in 2021. The consequences for consumers may be significant. Possession of a prohibited product may be charged as a state jail felony, carrying between 180 days and 2 years in prison and a fine of up to $10,000. Businesses face separate risks. Retailers may lose their consumable hemp licenses, receive fines of up to $10,000 for each violation, and face criminal charges for manufacturing or distributing a Schedule I substance. Texas has about 14,000 licensed consumable hemp retailers. Industry estimates suggest the restrictions could remove between 60 and 90% of products from some parts of the market. One Austin retailer expects to lose about half of its inventory. Another anticipates a 25% reduction in sales after moving away from Delta-8 and THCA products. Supporters of the restrictions point to the product's psychoactive effects and an increase in cannabis-related poison center calls, particularly those involving young children and teenagers. Hemp industry groups warn that the rules could close stores and push consumers toward unregulated products. The legal hemp market will continue, but it is expected to focus more heavily on Delta-9 products that comply with the federal dry weight limit. At the same time, Texas hemp businesses have lost another temporary legal protection involving the state's broader consumable hemp regulations. The Texas 15th Court of Appeals denied an emergency request to preserve an injunction issued by a lower court on May 1st. That earlier order had prevented the Department of State Health Services from enforcing major portions of its consumable hemp rules. The appeals court did not decide whether those rules are legal. The lawsuit remains active. The ruling does mean that the department is no longer blocked from considering enforcement while the case continues. A central issue in that dispute is the state's Total THC Rule. When the state determines whether a product complies with THC limits, the rule counts THCA as 88% delta-9 THC. THCA is common in hemp flower and other consumable products sold throughout Texas. Retailers may now need to review which products qualify under that calculation. Products that do not qualify could have to be removed from sale. Lucas Gilkey, chief executive of Hometown Hero and a leading figure in the Texas Hemp Business Council, says small stores are likely to feel much of the effect. Estimates from Whitney Economics and a University of California Davis researcher indicate that smokable hemp represents well over half of the Texas market. The Department of State Health Services says it is still deciding how to proceed because the lawsuit has not reached a final ruling. That means the rules may be enforceable, but the timing and scale of enforcement remain unclear.
Delaware is creating a separate regulatory system for hemp-derived THC beverages. Governor Matt Meyer signed House Bill 373 on July 23rd. Most of the law's provisions take effect October 21st, while the new taxes begin February 1st, 2027. The law allows adults who are 21 or older to buy qualifying beverages from licensed package stores and retail marijuana stores. Certain authorized microbreweries may also manufacture and sell the drinks. Single-serving containers may contain no more than 10 milligrams of delta-9 THC. Multi-unit packages are capped at 60 milligrams. A 750 milliliter bottle may contain as much as 170 milligrams. The beverages must be non-alcoholic, and the delta-9 THC must be extracted directly from hemp. The products may also contain other cannabinoids, including CBD, CBG, CBN, or CBC. Package stores will have to display THC beverages separately from alcohol and ordinary drink mixers. Packaging designed to appeal to children is prohibited. Each container must also carry a state-approved THC symbol and a warning that the product is restricted by age. Mail delivery and third-party delivery will not be permitted. Package stores may, however, accept online orders for in-store pickup or curbside transfer. Delaware will tax single-serving containers at 50 cents each. A 750 milliliter bottle will be taxed at $8.50. That revenue will go to the Marijuana Regulation Fund. The state-regulated market will still face uncertainty at the federal level. The Delaware law requires beverage sales to end if federal restrictions classify the products as controlled substances. Delaware has therefore created a detailed state system, but future decisions in Washington could determine how long that system remains in operation.
San Francisco is moving closer to opening cannabis cafés, where licensed retailers may serve food and non-alcoholic beverages alongside on-site marijuana consumption. Mayor Daniel Lurie signed the city ordinance on July 23rd. The Office of Cannabis is scheduled to begin accepting permit applications on August 23rd. Businesses will need both a cannabis permit and a consumption permit from the Department of Public Health. They must follow restaurant food safety requirements, verify customers' ages electronically, and prohibit alcohol and tobacco. The ordinance follows California Assembly Bill 1775, which was signed in 2024 and allows local governments to authorize cafe-style cannabis businesses. Supporters say the model could transform a brief dispensary purchase into a broader hospitality experience. They expect cannabis cafés to attract visitors, help licensed retailers compete, and bring additional customers to nearby businesses. The debate, however, has focused heavily on indoor smoke. The American Lung Association says cannabis smoke contains toxic chemicals, carcinogens, and fine particles that are also found in tobacco smoke. Opponents argue that cafe employees and people in neighboring properties could face repeated exposure. State law requires N95 masks and warnings about smoke-related risks, although health advocates say those protections are not sufficient. 4 members of the San Francisco Board of Supervisors opposed the ordinance. The city has not announced how many permits it will issue or when the first cafe will open. San Francisco's rollout could become a test for other California cities considering the same model.
Vermont adults may now legally purchase and possess up to 2 ounces of cannabis, twice the state's previous limit. The new law, Senate Bill 278, also doubles the legal hashish limit to 10 grams. Retail purchase equivalents are increasing as well. An adult may purchase up to 28 grams of concentrates, 16 1-gram vape cartridges, or edible products containing a combined total of 16,800 milligrams of THC. State officials say the change could help licensed retailers compete with the illicit market. Some dispensary owners say larger transactions may lower prices and save regular customers an additional trip. Others are less certain about the practical effect, noting that most customers did not reach the former 1-ounce limit. The law also creates a 2-year pilot program for 10 public cannabis events through July 2028. Licensed retailers may host the gatherings, where customers will be able to meet local cultivators and purchase regulated products. Cannabis consumption will not be allowed at the events. The law also changes certain rules affecting renters. Residential leases may no longer prohibit cannabis possession or impose a blanket ban on cannabis use inside a dwelling. Landlords may still prohibit smoking and other forms of cannabis use involving lighted, inhaled products. For businesses, the law eliminates Vermont's integrated cannabis license and cuts outdoor cultivation fees in half. Vermont is also preparing for the possibility of future cannabis commerce beyond its borders. The governor may pursue interstate cannabis agreements if federal law changes, federal enforcement is restricted, or state legal officials determine that cross-border trade would not create a significant risk. Interstate cannabis sales remain prohibited for now. The most immediate change is straightforward. Vermont adults may legally purchase and possess more cannabis in a single transaction.
Colorado has provided an early look at how physician-directed medical cannabis might fit into a workers' compensation system. The state's Division of Workers' Compensation reimbursed a 74-year-old retired worker for cannabis products used over a 12-month period. The patient had a long-standing back injury, chronic pain, and a history of opioid dependence. The program covered only oral products. Those included gummies containing THC and either CBD or CBN. Smoked and vaporized cannabis products were excluded because of concerns about respiratory effects and inconsistent dosing. During the program, the patient reported less pain, improved mobility, a better quality of life, and greater psychosocial stability. The patient also voluntarily reduced hydrocodone use by 17%. Researchers reported no adverse safety events. State officials later said the patient stopped using both opioids and THC after the formal study period ended. The findings come with substantial limits. This was a one-person evaluation, not a controlled clinical trial. Researchers cannot conclude that cannabis caused the reported improvements. Frequent physician contact and coordinated care may also have contributed to the outcome. The project's clearest finding was administrative. It demonstrated that a patient could purchase approved cannabis products from licensed dispensaries, submit the receipts, and receive reimbursement through a state workers' compensation program. Colorado insurers still cannot be required to pay for medical cannabis. Any broader adoption would therefore be voluntary. The participant was also retired, so the project did not address impairment at work, workplace safety, or decisions about returning an employee to the job. For patients, the program may point toward improved affordability and closer medical oversight. For employers and insurers, it also demonstrates how many clinical, legal, and safety questions remain unresolved.
Utah is preparing to license an additional independent medical cannabis pharmacy, with an emphasis on rural and medically underserved communities. The Utah Department of Agriculture and Food will accept applications from August 3rd through September 2nd, 2026. After reviewing the submissions, the Specialized Product Authority Licensing Board will select one applicant. House Bill 54 requires the state to issue the license before January 1st, 2027. The pharmacy must be located in a medically underserved area and in a county classified as 3rd, 4th, 5th, or 6th class. The operator must also demonstrate that it can keep the pharmacy operating in that community for at least 15 years. Ownership restrictions are a major part of the process. The new licensee cannot hold a financial interest in an existing medical cannabis pharmacy. It also cannot be owned by an entity that already holds such an interest. Applicants must submit a detailed facility layout, a security plan, and operating procedures for dispensing products, maintaining inventory, and consulting with patients. They must identify qualified pharmacists and technicians, demonstrate knowledge of state cannabis regulations, and show access to sufficient financing. Utah reported 115,472 active medical cannabis patient cards as of June. The state also reported more than 1,000 registered recommending providers and hundreds of registered pharmacy, cultivation, processing, and courier agents. The additional pharmacy could reduce travel for some rural patients, although its effect will depend on the location ultimately selected. Applicants now have 1 month to submit plans for a secure, independent pharmacy designed to remain in its community for at least 15 years.
Hawaii medical cannabis patients are preparing for a transition to a new state registry website. The Department of Health's Office of Medical Cannabis Control and Regulation plans to launch the new patient registry on August 12th. To prepare for the change, the existing website will stop accepting applications, renewals, and account updates from August 7th through August 12th. Patients will not be completely locked out during that period. They will still be able to sign in and download an existing 329 card. Dispensaries will also remain open, allowing registered patients to continue purchasing medical cannabis. The state has not announced any changes to dispensary hours, available products, or purchasing procedures. After August 12th, patients will need to use the new registry to download a new 329 card. Patients who receive physical cards through the mail will receive replacements shortly after the new system launches. The department previously advised patients whose cards were approaching expiration to meet with their doctors and submit renewal applications before July 29th. It has not said whether cards that expire during the shutdown will receive temporary extensions. Several other details have not yet been announced. The state has not released the address of the new registry website or explained whether existing usernames and passwords will transfer to the new system. The Office of Medical Cannabis Control and Regulation says it will release additional information and user guides. Patients with questions may email medicalcannabis@doh.hawaii.gov or call 808-733-2177.
The Michigan Supreme Court has changed how police may use the odor of cannabis during a traffic stop. In a 5-2 decision, the court ruled that the smell of marijuana by itself does not establish probable cause for a warrantless vehicle search. Evidence suggesting only a low-level civil cannabis violation is not enough either. The case involved Freddie Wilkins III. A Michigan State Police trooper stopped Wilkins for speeding and smelled cannabis through an open passenger side window. Neither person in the vehicle appeared intoxicated, and the officer could not see any marijuana. Both occupants were under the age of 21. The passenger later admitted that she possessed a small quantity of what she described as shake. The officer searched the vehicle and discovered a firearm. Wilkins was then charged with carrying a concealed weapon. Michigan's highest court said police needed probable cause to believe the vehicle contained a criminal quantity of marijuana or evidence connected to another crime. Possession of a small amount by someone under 21 is treated as a civil infraction. The court also noted that the smell of cannabis does not reveal how much marijuana is present. The ruling follows Michigan's legalization of recreational cannabis for adults in 2018. Because some possession is now lawful, the smell of marijuana no longer points automatically to criminal activity. Police may still consider cannabis odor as one part of the total circumstances. A search may remain lawful when additional evidence supports probable cause. The Wilkins case now returns to Kent Circuit Court, where a judge will decide whether the prosecution continues.
Rhode Island is preparing to restart a cannabis retail licensing process that was halted by a federal court. The dispute focused on a state rule requiring cannabis businesses to be majority-owned by Rhode Island residents. California entrepreneur Justina Jensen challenged the residency requirement under the United States Constitution's Dormant Commerce Clause. United States District Judge Melissa Dubose halted the licensing process on April 8th. Governor Dan McKee signed 2 bills on June 10th, removing the residency language. The revised law also canceled the original application round and instructed regulators to start the process again within 60 days. That creates an August 10th deadline. 75 prospective retailers are expected to receive refunds of the $7,500 application fees they previously paid. The Commission is contacting those businesses to confirm the names and addresses that should appear on the refund checks. Regulators must also develop a new social equity certification process. Applicants will still have to demonstrate that a business is majority-owned by people disproportionately affected by previous cannabis enforcement. Those criteria may no longer depend on Rhode Island residency. The Commission says it expects to meet the restart deadline, although the precise date remains uncertain. Before the process can resume, the Federal Appeals Court must return the cases to Judge Dubose so that she can formally lift the injunction. Until additional licenses are issued, Rhode Island's adult-use cannabis market will continue to be served by 8 existing medical marijuana operators.
New York Governor Kathy Hochul is facing a decision on a cannabis labor bill that has divided licensed businesses and worker advocates. Senate Bill S-10643 and Assembly Bill A-11562 would establish a 3-member cannabis industry wage board. 1 member would represent licensed cannabis businesses. A second would represent the New York State AFL-CIO. The state labor commissioner would appoint a member of the public to serve as chair. The board would examine compensation for workers involved in cannabis cultivation, processing, packaging, distribution, retail, and delivery. It would be required to hold at least 3 public hearings and submit its recommendations by December 31, 2027. The legislation would not immediately increase wages. The board could recommend pay increases, propose an industry-wide minimum wage, or conclude that existing compensation is adequate. The proposal would also repeal cannabis-specific labor peace agreement requirements. Cannabis license applicants would be required to publicly disclose their ownership structures, management agreements, employee pay ranges, and average scheduled working hours. The Cannabis Association of New York is asking Governor Hochul to veto the legislation. The association says licensed businesses are still contending with regulatory delays, limited access to capital, and competition from unlicensed sellers. It warns that small companies and businesses owned by social equity participants could face the greatest pressure. Supporters say the legislation would promote fair treatment for workers and improve transparency throughout the industry. If the governor signs the bill, the wage board provisions will take effect January 31, 2027. The board's first public hearing would have to occur by March 1st.
Idaho's latest attempt to place medical cannabis before voters has failed, although the dispute surrounding the petition drive continues. The Natural Medicine Alliance of Idaho submitted more than 150,000 signatures for the proposed Idaho Medical Cannabis Act. After county certification, only 58,024 signatures were counted as valid. The campaign needed 70,725 valid signatures. It also had to reach a 6% signature threshold in at least 18 legislative districts. The campaign reached that threshold in 13. An attorney representing the campaign says more than 10,000 signatures may have been rejected for technical or legally questionable reasons. The disputed rejections involve signatures without dates, inactive voter records, petition sheets containing signatures from multiple counties, circulator residency requirements, and other petition form rules. Secretary of State Phil McGrain says his office received numerous complaints about the campaign. Possible illegal conduct was referred to the Idaho State Police. That includes a signature attributed to a person who died in 2021. The campaign says it has zero tolerance for fraud and will cooperate with investigators. It will not, however, file a lawsuit seeking access to the ballot. The proposed initiative would have created a limited medical cannabis market with 3 initial vertically integrated licenses. It also included patient purchase limits and protections involving employment, housing, and education. Those changes will not take place through this year's election. Idaho voters will instead consider a constitutional amendment that would reserve cannabis legalization for the state legislature. If approved, the amendment would prevent future cannabis legalization through citizen initiatives. Reform would remain in the hands of state lawmakers, who have recently opposed the medical cannabis proposal.
That concludes this week's cannabis policy briefing. Texas is moving toward a more restricted hemp market, while 2 legal disputes continue to shape enforcement. Delaware is establishing detailed rules for THC beverages. San Francisco is preparing to accept cannabis cafe applications. Vermont has doubled its possession limit and authorized a pilot program for public retail events. Colorado has demonstrated that cannabis reimbursement can be administered through workers' compensation, although its one-person evaluation leaves major clinical and workplace questions unanswered. Utah is seeking a long-term medical cannabis pharmacy for an underserved community, while Hawaii is preparing patients for a new online registry. Michigan has limited the use of cannabis odor as a basis for vehicle searches. Rhode Island is working to restart retail licensing without a residency requirement. New York is debating a cannabis wage board. And Idaho's proposed medical cannabis initiative will not appear on this year's ballot. Subscribe wherever you get your podcasts, and join us again next Saturday at 9 a.m.